Will is defined as wish, desire, pleasure, inclination, choice, the faculty of conscious and especially of deliberate action. It is purely and solely a mental process to be ascertained in a prosecution for rape why what the prosecuting witness may have said or done. It being a mental process, there is no other manner by which her will can be ascertained, and it must be left to the jury to determine that will be her acts and statements as disclosed by the evidence. It is but natural, therefore, that in charging the jury upon the subject of rape or assault with intent to commit rape, the court should have almost universally and in many cases exclusively discussed consent and resistance. There can be no better evidence of willingness is a condition or a state of mind, no better evidence of unwillingness than resistance. No lexicographer recognizes consent as a synonym of willingness, and it is apparent that they are not synonymous. It is equally apparent, on the other hand, that the true relation between the words is that willingness is a condition or a state of mind, and consent one of the evidences of that condition. Likewise, resistance is not a synonym of unwillingness, though it is an evidence thereof. In all cases, therefore, where the prosecuting witness has an intelligent will, the court should charge upon the elements of consent and resistance as being proper elements from which the jury may infer either a favorable or an opposing will. It must, however, be recognized in all cases that the real test is whether the assault was committed against the will of the prosecuting witness. Broadly, this court has accepted and followed the judgments referred to in the above judicial dictionaries as regards the meaning of the word consent as occurring in section 375 IPC. It is not necessary to refer to all the decisions, and the reference to two decisions of this court shall suffice. In a state of HP versus Mangoram, a three-judge bench of this court, while dealing with the aspect of consent for the purposes of section 375 IPC, held at page 230 of the report as under. Submission of the body under the fear of terror cannot be construed as a consented sexual act. Consent for the purpose of section 375